Hello, this is Brad Harvey with Harvey Investment Management. Today we're going to talk about the basics of estate planning, part 2, which really has to do with financial affairs. During part 1, we talked about healthcare matters and what do you do prior to your death. Well, this is part 2, which has to do with your orderly affairs upon your death. And just like in part 1, you need to decide what are your goals. What do you want to happen with your estate? Does it all go to a surviving spouse, or if the spouse is unavailable, to children or grandchildren or charities? That's all up to you, but you should know exactly where you want your money to go upon your death. Today in the United States, gift taxes on an estate do not trigger until your estate value is over $11.4 million. So, over $11.4 million, yes, you have to pay taxes on that, but under that amount, it's a tax-free transfer. So for husband and wife, it's actually $22.8 million if they're married and both citizens of the United States. There is a little bit of an exception there. Make sure you do have a citizen spouse if you're going to be following these recommendations. So, that's the estate value. Remember, life insurance proceeds are also included in your gross estate, so make sure that keeps you underneath the $11.4 million or $22.8 million for a married couple. So first and foremost, let's talk about documents. We need to make sure that we have the correct documentation so that your estate is transferred efficiently. Beneficiary forms, that's where we start. Our IRAs and retirement accounts and insurance policies, are they naming a spouse? Are they naming an estate? Are they naming some other beneficiary or a charity? Make sure those beneficiary forms are accurate and they say what you want them to say. Keep in mind, you can also add a transfer on death designation to most bank accounts and security accounts in the United States. So, those are the beneficiaries. Next document, last will and testament. This is where you spell out exactly what you want to happen with your affairs that were not subject to beneficiary designations. Those beneficiary designations are what we refer to as contractual transfers. Although they're part of your estate and potentially taxable, they actually don't get to your last will and testament. And if you have trust, typically the trust money does not go to your last will and testament. So that leads me to my next point, trust. Do you need a trust? Do you need a revocable living trust? If you have property outside of your residential state, might be a good idea. That's something you want to talk to your estate planning lawyer about. Plus, powers of attorney. Now, powers of attorney, while included in estate planning documents, actually terminate upon your death. You're granting someone the power to sign your name if you're unavailable or unwilling to sign. Well, upon your death, you can't sign anything, therefore your power of attorney dies with you. Very important concept. And the last thing is, once you have all of these documents executed, scan them, password protect them, and put them onto your cell phone. Make sure you have those available to you so that if there's an issue, and make sure your next of kin has them, they can pull them up and email them with the password, unlock it, so that those people know, hey, I've got power of attorney. Or they know exactly what it is that you wanted to do. Make it easy on them. Don't worry about where the paper copy is, which is very important. But if you have a scanned copy on your phone, it's very convenient, especially as the Part 1 documents become relevant on the healthcare side. So, this is Brad Harvey talking about estate planning documents and process. Part 2, financial transfers. Thank you very much for tuning in. If you have any questions, give us a shout. We'll be glad to answer them. Thank you.